may get a call I have to take.
Okay, you are so excused.
What's that, pen? Say it again. There you go.
Lisa, is Mike gonna cue us?
He is not. You may just begin at 10 a.m. Everything is ready to go.
Okay. Meeting will begin shortly. That sort of implies it might not be on time. All right.
Just go ahead and start.
Good morning. Welcome to the Oak Island Board of Adjustment meeting for Wednesday, July 9, 2025. We are now called to order. The first item on the agenda is selection of a chairman and then vice chairman, and I now open it for nominations.
I will nominate Charles Farley for another term as chairman.
Thank you, Mr. Uhas. Do I have a second? All in favor, please say aye.
I was gonna nominate somebody, but
And now, we need to nominate the vice chairman. If I don't hear anyone make a nomination, okay.
Steve Ulas.
Okay, second.
Second that.
And it's been motioned and seconded. All in favor, please say aye.
What was, excuse me, what's the question?
We
Did
have
you
a
say you were gonna
procedural
nominate
glitch
somebody?
here.
Oh, I think
She did.
what the chair said, he needed a nomination now for vice chair.
Right.
And so who made the nomination for vice
No,
chair?
that wasn't the question.
Be
That's
down at
okay.
the far end.
Okay.
Okay. And who seconded that?
That's me.
Okay.
And it was unanimous. For the record, okay. Next thing is the approval of the minutes from our last meeting. We've all looked at them. Are there any errors, additions, or subtractions, clarifications? Mr. Uhas?
I will move approval of the minutes as written. I'll second.
Second, we have a second? Get that? Okay.
Yes, sir.
All right, as it stands, then, the minutes are approved.
You can call the vote.
Mr. Golden, there's no old business?
You gonna vote on the motion?
Old business?
Vote on
no?
the motion for
Okay.
the minutes.
The new,
Let's have a vote on the minutes, even though we didn't.
okay. All in favor of approving the minutes?
All right.
Minutes are approved. New business is a variance, 5061 Glen Cove Drive. The hearing on this matter is quasi-judicial in nature and will be conducted in a manner consistent with courtroom decorum. Members of the board may ask questions of each witness after the witness testifies and when questions are called for by the chair. The testimony that witnesses shall give today will be under oath. If the witness wants the board to see written evidence, then he or she should be familiar with the evidence and explain the document and ask that it be introduced during the end of his or her testimony. Any attorneys who are going to speak should not give factual testimony, but may summarize their client's case. Do we have an attorney today? Okay. After all testimony, the board will deliberate and make a final decision based on substantial, competent, and material evidence in the record. The board cannot make its decision based on evidence or information that is not part of the record. The final decision of the board will be recorded in writing and will include findings of fact and conclusions of law. Everyone who is going to participate in this, please come to the front and the clerk will swear you in.
Place your left hand on the Bible and raise your right, and I can do that for you. Raise your right. Do you solemnly swear that the evidence you give to the Board of Adjustment shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
We will now hear from the town attorney.
Sure, thank you. Before opening the hearing, board members should reveal any possible conflicts and withdraw from these proceedings if necessary. Conflicts include, but are not limited to, a member having a fixed opinion prior to hearing the matter that's not susceptible to change, undisclosed ex parte communications, a close familial, business, or other associational relationship with an affected person, or a financial interest in the outcome of the matter. If an objection is raised to a member's participation and that member does not recuse himself or herself, the remaining members shall vote as to whether to continue to have that member participate. Board members should also disclose at this time any knowledge, any special information or knowledge that they may have about the case, including any site visits to the property.
Board members?
Out of abundance of caution, I am the president of the South Harbor Master POA. But I don't know these people.
And it wouldn't affect your decision in this matter.
Just an abundance of caution.
Okay, thank you, thank you. We're good.
And there were no site visits, although that's not verboten.
I've been there 150,000 times.
All right, thank you. I think we've cleared that hurdle. All right, explanation of the proceedings. In this hearing, we will hear first from the town staff, and then from the applicant and its witness, and then from any proponents or opponents to the request. The applicant may, if it chooses, reserve time at the end for rebuttal. Parties may cross-examine a witness after the witness testifies when witnesses are called for. Again, if you want the board to see written evidence such as reports, maps, or exhibits, the witness who is familiar with the evidence should ask that it be introduced during or at the end of his or her testimony. Note, by law, some kinds of evidence can only be given by an expert. For example, opinions about property values and whether an increase in vehicular traffic resulting from the proposed use would pose a danger to the public safety. With guidance from the town attorney, I will correct you if you do not follow proper procedures, and I will rule on all objections. Before you begin your testimony, please clearly identify who you are and your address for the record. There is no time limit on how long you may speak, but I ask that you be considerate of everyone's time and concise with your comments. Also, I can and will stop any testimony that is irrelevant, incompetent, or immaterial. I now open the public hearing. I will now ask Brady Goldman to make the presentation of this request.
Thank you, Mr. Chairman. And good morning, Board.
Mr. Golden, is your microphone on?
Hello.
Yes, thank you.
So today's item is variance request for relief to section 32-74 of the Unified Development Ordinance. It is at 5061 Glen Cove Drive. My name is Brady Golden, I'm planner one for the town of Tyler. So a little bit of background on this situation. The property is located again at 5061 Glen Cove Drive, tax parcel ID 236D076. The property is zoned commercial low density, which is CLD. The applicant has requested a variance for relief from the tree planting requirements of chapter 32 of 3 for a proposed deck addition. Section 32-74 is the requirement for when vegetation plans are required, and a building permit which was requested for this deck addition was submitted and also required a vegetation plan. Section 32-76 gives the guidelines for tree and vegetation requirements. This lot is a little over 7,500 square feet, which would equate to about 36 dBH, which is diameter at rest height for tree. Additionally, we do have Bryce Taylor here, tree canopy manager, for any technical questions regarding tree planting. Here is a vicinity map of the property highlighted in blue. And the zoning map of the property, mainly surrounded by commercial low density. Additionally, here is a survey site plan for the property in question, showing the proposed deck north near the rear of the property. And as far as tree requirements, what's currently there, what's being proposed, what's being requested, the applicant can use some information as well as what the request is. Here are the variance standards. I'll go over those. Got these up here for you, and just wanted to make a note that a variance requires a concurring vote of 4/5 votes of the board in the affirmative for approval. That's what I have. I'm open to any questions.
Does the board have any questions for Mr. Goldman at this point?
I do. This property is zoned CLD. Would the planting requirements be different for a lot of the same size if it was a strictly residential zone?
No, sir. So the tree requirement applies to all types of development, all zoning districts. So no matter if this was a residential development in a R6 or CLD, the tree requirement would be consistent.
Thank you.
Any more questions for Mr. Golden?
I have a question. How many trees, et cetera, are being required to be removed?
So as far as the removal of trees, I don't believe any. I think the applicant may speak on that.
Then, okay, I guess I don't understand the reason for the tree issue.
So anytime there's a building permit or development permit, per the update of chapter 32, it is a requirement for that property to meet today's standards for tree requirements, and that is based on the diameter at rest height. Not a number of trees, but a collective measurement of trees.
Well, did that meet the requirement before the request for the deck?
So it's, anytime there's a new proposal on a property, that's when they have to meet today's standards. So as far as if it met the old ordinance prior to, that doesn't come into play because today's standards will come into play for new permits.
So they can't be grandfathered?
No, sir.
Thank you, Mr. Golden. We will now hear from the applicant.
Before
Mr.
we
Chair,
do-
you might want to go ahead, and one of y'all might want to,
I think before we do that, I would like to make a motion that we enter the staff report and the staff testimony into the record as Exhibit A.
Exhibit A for Mr. Golden's
I'll second that.
presentation.
I'll second that.
Okay, the board, looks like it's unanimous. That is so entered. Thank you, Mr. Golden. Thank you, Vice Chairman. Okay, we will now hear from the applicant. State your name and address, please.
Good morning, my name is Robert Loyne. I'm here with my wife and some friends, of course. We reside at 5061 Glen Cove Drive. I don't know whether any of you are familiar with Glen Cove, but it is located close to the Park Creek Golf Course. It is a small street with some very well-established homes, very well kept, the homes and the properties themselves. Our house has an established yard, been there for over 20 years now. What we have requested is that we be allowed to add an additional screened-in covered porch to the back of the house, and that's what, I guess, set off the storm about planting the trees. As it turns out, the city is requesting that we plant 17 2-inch caliber trees. These are trees that are 2 inches wide at breast height. These trees come in very large pots. They come in about a 45-gallon pot. So they have to be handled by some sort of machinery to even get them moved onto the property. Anyway, to make a long story short, we would like to request that this requirement be waived for our property. We're not saying that we would not plant some trees, but we don't think we need the caliber of trees that the city is requesting. These are very large trees.
Have something more, sir?
Sir?
Do you have something additional?
Yes, I have some other information I'm trying to get my hands on here. Sorry. Okay, well, let's start. On our application, we included some information about the property itself. One of them, of course, was the, I don't know how you get this up on the screen, but anyway, this.
I believe we have a copy of that, don't we?
Okay, this
Yeah.
shows the location of the house and the location of the neighbors. We back up to the golf course and we sit on the 16th hole, so we have a very nice view of the golf course. We can see all the way over to Vanessa, which is completely on the other side of the golf course. And we can see all the 17th and the 18th and the 16th hole. And we do not want to destroy that view. And that's why we have built, are trying to build the screened-in covered porch. You'll find this piece.
Not sure we have that. Board members?
It should be, it was part of the application.
you know, it might be helpful, maybe Brady, if we put the agenda, put those up, or put them up somehow on the screen so we can see what he was referring to. Maybe it's too difficult to do that.
Mr. Golden, Mike is not here.
Part of the presentation.
Okay, all right,
And
sorry.
I believe that that's page 12. of
Okay,
the-
or maybe we can just identify it by page number, or I see like plan number 1, plan number 2.
Page 12 of the,
You got it, John?
I got it.
Yeah, okay.
yeah,
Sorry.
this is page 12. You need to see this?
Got it.
Okay. I'm not sure what the formula is for figuring the requirements for the trees. I'm assuming that they says you gotta have so many trees per square foot.
Do we have someone who'd like to speak?
I can.
Have you been sworn?
Yes, sir.
You have to
Okay.
speak from the podium. Thank you.
It's okay.
The square footage on Bryce Taylor
Oh,
Store.
Are you Mr. Bryce?
Yes, I am.
Oh, okay, all right.
I'm the storm administrator and the tree canopy manager for the town. Good morning. Calculation of DVH is calculated on the square footage of the lot. This gentleman here is required 35.29 square feet of DVH in trees. DVH is calculated by, for new plantings, is calculated by the American Nursery Standard, which is 1 foot above the planted base, 2-inch caliper width. Because of the 2-inch caliber at rest height, a tree would be 45 to 50 gallons. We are allowing 25-gallon trees, smaller 12-foot trees that they're measured at 1 foot above the base. So based on my calculation, he is required 35.29 DBH for this lot. With that said, we have the option of the buy down, 30%. 30% of the buy down would cost him $2,717. That would give him 24.7 DBH he would need to be required to plant. That's 12 trees. So that helps. That's my calculations as of the full site.
I have a question.
Yes, sir.
When was this new plan enacted?
This is enacted April 15th of last year.
Okay, so you're $1 short.
We require it for any development, it's listed as chapter 32 for any development, for a new swimming pool, for a new addition, any development, any building permit whatsoever. And we've done it for every single permit that came through our office. The only thing we do not is just like if you're reworking your driveway or doing some small maintenance stuff to what's existing in the envelope.
Question?
Yeah, the 30% buy down number, how does that calculated?
It's calculated per DBH, it's $250 per DBH inch.
Okay, and is that's based on a retail price or an installed price of the trees?
That's per our ordinance, sir. So
Per the ordinance?
it's written in the ordinance.
I see, okay. Thank you.
Thank you.
Thank you for your input.
Thank you very much.
You may continue.
Okay, so let me comment on what he said. So you're gonna charge us $2,700 to cut the number of trees that you want us to plant?
The town or the city isn't charging you directly, but we hear your point.
All right, to start with, we mentioned the cost of the trees. I have researched the cost of these trees with 2 of the nurseries. These trees that we're talking about, if we had to use the 2-inch DBA tree, they're about $300, $250 to $300 per tree. There is a transportation cost to get the trees moved from the nursery to my location. And then we would have to pay someone to plant the trees. My understanding is they would charge about what the tree costs to plant it. So we're looking at somewhere between $450 to $550 per tree to have them planted on the lot. I want to address the size of our lot, please. I guess when they do the calculation of the square footage of the lot, they don't take into account what's under the ground. And that's what this drawing shows here. Did you ever find it?
Which page number is that, sir?
This is page 12
Okay.
of the ordinance. Like, do you have pages 14? You do have that?
Mm-hmm.
If you look at if you look at this, well, you don't have the drawing, do you? Would you like to see this?
We've
we
got
have it.
that.
We have it.
We have
The
it.
agenda packet.
Yeah, if you just say the page number, we have it.
So if you look at the drawing, I have sketched out the green area, which is the usable surface of our yard. The yard is split in half, and the street side is the right of way. So we can't plant any trees on the city's right of way, so that's not part of our yard. So that needs to be taken into account. Under the yard, you have the sewer line that runs from the street to the left-hand corner of the house. Then next to that, you have the water lines that run from the water connection up to the house. And beside that, there is an irrigation line that runs under the ground. So all that area there is not plantable. We can't dig down and put trees on top of all these areas. And the irrigation runs all the way around the property. And then we have vegetation that's growing all the way around the house. This is vegetation that's probably been there for 20 years now.
Is the irrigation unique to your property, or is every house in the subdivision?
Probably every house in the subdivision has their own irrigation, and they're all run, the pipes are run under the ground all over. For instance, in the back of the house where I put in the addition, it's a major 4-line irrigation pipe system that runs crisscrossing the backyard. So you have to be very careful where you try to dig back there, so we had to make special arrangements. I had to move those pipes so that they could put the footings in.
Is that water separate metered from your?
It's separately metered, yes.
Okay, thank you.
Yes, it is. So anyway, all these things are obstacles that cause problems if you're trying to plant all these big trees.
Is there I'm sure there's a specific type of tree that is required.
There is, the city has a list of trees that they want you to plant,
Could you name a few of them, please?
and that's here. Okay. All these trees are, you see that oak out there?
Yes,
It's outside the window, that is a
the live oak,
live oak.
okay.
All right, we're talking about planting 17 of them.
What are other options for trees?
Red oaks, hickories, southern red oaks, Schumann oaks, black gums, eastern red cedars, the live oaks, southern magnolias, cherry laurels, and something called a red bay tree.
No palm trees.
No palm trees. No small trees. All these trees grow 80 feet wide and 80 feet tall when they're mature. We currently have 2 of them growing in the natural area next to our house. If you can look at this one, you'll see a picture of one of them.
What page is that?
And that tree is growing over the top of my house already.
Is that page
Yeah,
15?
Have the page,
Oh, that is page 15, I'm sorry,
page 15.
page 15. And if you look at page 16, you'll see the base of one of those trees in that natural area. The land management, the LRES group, they maintain that natural area between us and the Goff Village. They cut the grass, they maintain the trees, and they're constantly having to trim the lower limbs of that tree to keep it where I can even cut my grass. And right now, the trees, in the storm, it beats the top of our house there, so I've got to figure out a way to get those limbs cut. I've had to cut them before, just to keep them off of my house. So you can imagine having 16 more of these planted of that size in the yard. we're not saying that we don't need some trees. We already had plans to plant some additional trees in the back to create a separation, like a natural fence between us and the golf village that exists there. What we don't want to do is to put any trees in the back of the house to disrupt the view that we have of the golf course. That's why we bought the house to start with. If you look at picture number 17, you'll actually see the tree covering the top of the house. What I'm trying to do is just give you an example of how big these trees are going to get if we're required to plant any of them. And now, if you take this number 17 picture, if you look down here where it shows the sewer line, back in May, we had an issue, and I'm going to get off subject here for just a minute, issue with backup in our house of water, in the tub, in the showers, in the toilets. We had to call a Roto-Rooter service to come out and check it out, and they took the cap off of the city sewer, which you see in the picture, and that was not blocked. But I wish it was, because the city would have been responsible for fixing it. So they went up there under the bush and found our cap, and they took the top off, and of course the water gushed out of it. He put his camera down in the pipe, and lo and behold, the tree was growing inside of the pipe, the plastic pipe. Somehow the tree found a crack over the 20 years that the trees had been there in the property and had grown into the pipe and stopped it up. So we had to, he took his rotor and went through there and chewed up all the roots and cleared it up, and we had water flowing, but he found holes in the pipe. So we had to pay him to put 21 feet of new pipe in, which cost almost $1,800 because of the roots from the tree growing into the pipe. Here again, I mean, you can imagine all the trees that we have to plant in the future. All right.
Do you have anyone else who's going to speak on your behalf?
No, it's just me.
Okay, that's fine.
I thought Councilman Gates was going to be here today, but I don't see him. Anyway.
Board, any more questions for the
I
applicant?
have one for that gentleman, I can't remember your name.
Mr. Bryce?
What is the reasoning behind so many trees? Is it a water drainage issue, or what prompted that change in the regulation?
The Chapter 32 ordinance was developed based on large-scale development we've had over the years, recent years, and tree canopy loss. We have lost numerous amounts of tree canopy here on the island, and Chapter 32 was revised and ordered by council and into the system for this to allow bring that canopy back to the island. With South Harbor being an offset subdivision, being a developed subdivision off island, I know that for future developments, we are working with the development companies on what is allowed, what we can make allowances for, based on the lot size. I mean, some of these lots are 50-foot wide and they're 60-foot long. You can't hardly meet that ordinance when you put a house on it. But the newer subdivision are laying aside green space areas to count for the allowance of the total area of the development. So that's helping and assist with some of this tree cluttering, trying to get them all in one and meet the ordinance.
So I'm assuming the ordinance picked out these particular species of trees that would be hardy and would withstand weather conditions better?
Yes, sir. These 13 trees were approved by council. They were not selected by me. That was my predecessor. I am in the process of allowing more trees, adaptable trees, North Carolina heritage trees, and getting council to approve allowing a minimal, like an under canopy shade tree for a certain amount of DBH per lot, which would be a smaller tree. like your dogwoods, your other smaller under canopy trees. So we're working on this in revisions now of chapter 32. So. Yes, ma'am.
Are the property owners getting any credit for any trees? The one that we see overhanging on his roof?
No, ma'am.
That's-
If it was on the property line, we do count it. It is not. Apparently, he has 0 trees on this lot. So with his development, I mean, it's a tight fit. I understand his argument, but to meet the ordinance, that's what the requirement is at the point. So it's up to you to make the decision. I can make it says in the ordinance, I have the option to make, exceptions to the rule of the ordinance. And in my opinion, in South Harbor, with the large-scale development, I think that some of that should be, negated to a point, but I don't want to open up for every single residence and every single addition, as we have had not a single variance yet.
That's encouraging to hear.
I have a question for Mr. Lyon.
Yes.
Do you have an estimate on what the cost of the porch will be to get that built?
Yeah, it's $30,000. We have a permit, and the porch is already under construction.
Can I ask about Plan 2? And I believe it's page 11.
Okay, yes, ma'am.
This indicates larger trees being is
Yeah,
it
and
proposed?
that plan is totally impossible. These trees are so large that they have to be dug up by one of those big trucks and hauled. And then they have to dig the hole by a truck and plant them. The cost is astronomical. I just had a wild idea that, well, we gotta have 36 dBA, why not buy 36 6-inch trees and put them there? But after checking on the price and the cost, and you couldn't even get the truck in the yard to start with, we're gonna have trouble even getting some sort of machine to plant the smaller trees.
Mr. Bryce,
If we have to.
so no consideration is given by the percentage of the lot that's covered with building and utilities like sewer?
No, ma'am, we have not done that to present for any development. They've met it or they did the buy down. And our recommendation for like swimming pools where the area is really tight, to allow the ball cypress and the red cedars, because they're smaller and they grow tighter, they're not as high, they're not a large canopy shade tree, at this time, but they are eventually, 100 years from now, but they're compact and they can plant them closer together to achieve and to meet the standards.
I've got a question. So the lot size includes the area in the right-of-way?
Excuse me, say again.
The lot size that you use includes the area in the right-of-way?
It does,
But he can't plant there?
correct. Well, we are working, it does not. Oh, I'm sorry, it does not. That's my
If you'll
fault.
look at picture 14, you'll see I have divided the right-of-way from the front yard of my house, and you'll see how small my actual front yard is. It's like 18 feet wide, about 30 feet. These bigger trees have to be planted at least 10 feet apart because of the growth that they expect from them. The Oak Island approval of native plant material has a list of optional trees, but they don't allow those, such as Yopon hollies, which I have already on my property. Wax myrtles, we have a wax myrtle on the property also. These are pretty good sized trees already. They have multiple trunks, so you'd have to measure each trunk to get the dBA of the tree.
Are those trees volunteer trees?
They're already there. They were
Yeah,
planted
yeah,
there.
okay.
They've been there for years, and they are on the property. They don't consider crepe myrtles because they're a bush, but we got crepe myrtles that stand 30 feet tall already. Those don't count, of course. And then the entire house is circled by all sorts of shrubbery and vegetation that's been there for years. I have to keep them trimmed. I mean, some of them are as tall as I am already. All that vegetation is already there. All this is taking care of the erosion problem that we might have in the future. We haven't done anything to the land. We're just building the addition. All we've dug is footings. So we haven't changed the landscape. We do have to add I forgot what it's called. Oh, a stormwater management pit. This is a pit where the new gutter is going to be off of the building. You have to dig a pit 3 feet wide, about 3 feet wide, by 3 feet deep, fill it full of rock, run the gutter into it, and that's the management of the future water that'll run off the house. So we have to put that in to meet that particular requirement. So that's just part of the whole.
Did you say there's nobody here who wants to speak against your
Oh, I
getting
do
a
not know
variance?
about- I don't know about that now.
Yeah.
I have a question for Mr. Rice again.
Yes, Mr. Bryce, again, take the stand.
Yes, sir.
Did I understand you to say that in new development, there's some credit given for open space trees?
The DBA is calculated for existing trees on site. We can go in and we measure, prior to the permit, we'll go in and measure all the trees on the lot, and we'll get a calculation of what's existing if they're not in the envelope of the new development. Any tree in the envelope of the new development can be removed, whether it's a heritage tree or not, based on our ordinance. But take that calculation and then take the square footage of the lot, divided by 220, that gives you the DBH in trees required. So then they have to meet that requirement. So if you have say you have 17 DBH on your lot, and you need 30, you'll have to replant that with new plantings, per the ordinance. It also requires 1 per 25 feet of road frontage. You have to have 1 tree in the setback per 25 feet of road frontage.
I'm not clear, and I'm not sure that you answered the question that I asked. But if we have a new development, say 100 acres.
Okay.
And it sets aside 30 acres as open space, does the tree, do the trees on that 30 acres give credit to individual lots of the overall requirement of trees?
Yes, for new development, we have determined that is the best way to calculate that, because we can allow that wetland area or green space, to subside for the development.
Okay, so if, and I don't know what this particular development looked like, but if it was being created now and there was a certain amount of open space, then the requirement, the individual requirement for this lot would likely be less than what is required now, because some of those trees in the open space would give credit to the development as a whole.
Correct, if there was green space, but in this location in South Harbor, I don't believe the South Golf Course, I don't know much.
Okay.
I have two questions.
Yes, sir.
First of all, without the porch, his existing tree ratio is adequate.
Correct, it was inadequate.
But just because he's adding a porch, it's no longer correct.
Correct, because it's considered new development under our chapter.
New development. Now, let me ask you this. There is a house that it takes every square foot of legal space on that lot, all the setbacks, can't put a tree in the setback. What is he to do? He's got no room to put any trees.
Then this permit would be denied.
It would be done, but he'd have to leave how much space for the trees?
I have a question for the applicant. Are you requesting a reduced number of trees? And if so, how many? or no trees, and where would you plant any trees that you would find to be acceptable?
We're basically requesting that we not be required to plant any trees, but we're not saying that we aren't going to plant some trees, maybe trees of a different type, lesser size. We were gonna do that on our own anyway. But at this point, we would like to not have to plant any trees.
Well, hopefully there can be some element of compromise here. What about the town? Brady, do you have anything to add to this discussion?
One point I'd just like to clarify is that the applicant mentioned about, he's already got the footing start for the deck. Was the permit approved?
Yes.
Okay, so there is an approved permit, so under the approved permit, he has said that he will meet the tree requirement. So now, since he has an approved permit, he's starting on his project, now he's asking for relief. So no matter what happens here, the project won't be abandoned. It's either granted relief from the tree requirement, or he's going to have to plant whatever the vegetation plan is approved on the permit. That's what will have to be there before the project permit is filed out.
So basically, he's volunteered in the permit to do this.
He's meeting the tree requirement in his permit. And as of right now, before any type of decisions made by the board, he's going to meet that 36 dBH or whatever it is based on the size of the parcel.
And that,
Yeah, as part of the permit that was approved, provided the tree vegetation plan that met that requirement. And that's what the permit was approved under.
and would that be the Plan 1 that we see here in our packet? I think Mr. Loring.
Either one,
Page 10.
based on
Either page 10 or
Page
11?
10.
page 11, but either one of those would meet the requirement.
Okay.
That's based on.
And that was, those two plans were filed with the permit.
That is correct. I initial that page on the bottom right, page 10 with my initials, that was what he agreed to blank.
Okay, thank you.
Further discussion by the board?
Mr. Chair, someone, one of y'all ought to go ahead and enter up the agenda into the record, because we've been referring to it a lot.
We should enter into the record
The agenda and the attachments, you know.
the applicant's
Those were
testimony?
part of.
Did we already say that as part of Brady's?
Yes,
I know you said his presentation, I wasn't sure.
right. No, his agenda, the agenda packet and the presentation were included in that initial.
Okay.
But do we need a motion to include the applicant's testimony in the record?
No, you all can go ahead and start talking.
Okay.
At this point, I'll ask for a motion to, yes,
Ask if there's anybody who wants to go.
is there anybody else who wishes to speak for or against this application who has been sworn?
I have one more thing to say.
Well, you're,
We made the application for the variance on May the 18th. The permit was approved on June the 12th. This was after we requested the variance. But they went ahead and approved the permit.
all right, that's it for the information.
Thank you. Thank you very much.
Your testimony. We need to get the,
We need to go through the four
What?
variance standards.
say again?
We need to go through the four variance standards.
So we need to close the public.
Before we
hearing.
go through the standards, I've got to close the discussion.
Okay.
You all can,
May I say one more thing, please?
Sure.
I'd like to invite you out to my property just to observe what we're talking about putting these trees on.
Let's hope that won't be necessary, but that's a good suggestion.
Okay, thank you.
If there is no further discussion of the case,
yeah, Mr. Chair, you all can discuss among yourselves now, or you can close the public hearing and discuss
I will
among yourselves.
now close the public hearing,
Okay.
and we will take this into deliberation. There's a lot of options, things we could come up with, but
I feel for him, I really do, but he signed the permit knowing the situation.
It's a very, very expensive endeavor, but not necessarily, I mean, we all know these standards, area standards by heart.
Well, I think we should go through them one.
Okay,
one at
yeah,
a
we
time.
will. From now on, we will go through these one by one.
It gives us cover.
So I think the first standard is unnecessary hardship would result from the strict application of the regulation.
The Board of Adjustment shall vary any of the provisions of the zoning regulation upon a showing of all of the following. Number one, unnecessary hardship would result from the strict application of the regulation. It is not necessary to demonstrate that in the absence of variance, no reasonable use can be made of the property. How does the board find on that?
That's kind of a sticky situation there.
I think it creates a hardship.
Can be determined, kind of go either way depending on which way you're leaning. The problem I have with what he had in place was okay. It was fine. Then a new ordinance was adopted. And because all he wants to do is add a porch, now all of a sudden he has to place trees to his expense because of a city requirement. I think that's a hardship. That's my personal opinion.
So you would say it is a hardship, even though it is a gray
I don't
area?
welcome any debate on that.
And how do you?
I think there is a hardship, and I'm concerned, first of all, that there's no ability to plant in the right of way, and yet that's taken into the calculation.
You make a good
And
point on that.
also-
There's no ability to plant in the right of way, yet, personal experience before Mr. Bryce's tenure, the city forced my wife and I to plant 2 live oaks in the right of way. Anyway,
I'm also concerned with there's no consideration for utility lines, sewer lines, and I know the tree roots grow into sewer lines, and it's a mess.
there'll be a lot of neon paint all over that yard, huh?
Oh, yeah. So well, I don't know if this fits under this, but I do think it's reasonable to expect some plantings versus no plantings. And I realize there is a view of the golf course in the backyard, but I still think there's a place to put trees in the back.
How do you find on the hardship, Steve?
Well, it's a hardship. The question is whether it's an unnecessary hardship. And, I am leaning in this particular situation to think that it is unnecessary, given the situation with the house as it exists, and the fact that all this is occurring after the entire property was developed, and it puts it in a different situation than something that is new, something that occurs after the ordinance was adopted. So in that sense, I can see that it would be unnecessary.
I find myself in agreement on that because the house is already there and it's got to hew to the standards as if it was brand new. Mr. McClendon, what do you think?
I guess I'm troubled because what I'm hearing is they're looking to expand the types of trees. What I'm hearing from the applicant is he would prefer those types of trees, which are smaller and not going to be the oaks that end up being 60, 80 feet high, as opposed to native species that are 15 feet, 20 feet max.
The question to you is, are you finding it's an unnecessary hardship?
I think that part of it is unnecessary. The thing we need to think about, though, is if we let this go through, we're essentially eviscerating the ordinance for existing.
I think when we get to variance standard number 2, that's an appropriate place to discuss that particular issue.
Okay.
Can I ask, just, is there a way to allow for a reduced number of trees, or we are strictly holding this to no trees, 17 trees?
Depending on whether you decide to grant the variance based on the 4 different criteria, then you are permitted under the statute and under, your own code to impose appropriate conditions, provided they're reasonably related to the variance. So you could address that after you go through all 4.
That sheds new light.
Up to now, the consensus on number 1 is that, yes, it is an unnecessary hardship. Do we need to vote on that, or can
Well,
we
I think,
move to number 2?
because you have to meet all 4 of them, you all might want to just make sure you have consensus around all 4 of them before you start voting. That would be the way I would proceed, but you can proceed however you want.
All right, number 2, the hardship results from conditions that are peculiar to the property, such as location, size, or topography. Hardships resulting from personal circumstances, as well as hardships resulting from conditions that are common to the neighborhood or the general public, may not be the basis of granting a variance. A variance may be granted when necessary and appropriate to make a reasonable accommodation under the Federal Fair Housing Act for a person with a disability. That last paragraph, I don't think
Applies, does not apply.
applies here.
Well, let me jump in here and say that I don't believe that the hardship results from the conditions that are peculiar to the property. And as John suggested, if we think of this particular situation as being peculiar to the property, then it will apply to every piece of property where there is a difficulty or any kind of hardship resulting from the planting requirements. And I think, we can all feel for the applicant here, and we can all look at this particular property and say, well, I can understand why there's a problem, but that's going to be the situation, I think, in every property in an already developed subdivision, and so I think I don't believe that the condition is peculiar to the property. I think the condition is peculiar to the ordinance, and I would suggest that possibly the ordinance should be revisited in order to accommodate this particular kind of situation. But I don't think that it's our job as the Board of Adjustment to revise the ordinance.
I agree with that completely.
And you're warning that that's the typical slippery slope argument, but yeah, it kind of applies here.
So I would have to say that it does not meet condition number 2. The hardship is common to all properties that are similar in size and have already been developed.
So it looks like, unfortunately, this variance will not be granted. Do I need to read the next 2?
I have another
Yes, you had a
comment,
question?
because somewhere in here, I would like to know, and I've asked, can we make it some trees, just not 17 trees? And that wouldn't be negating the ordinance, that would be,
Yeah, you can only impose those kind of conditions if you grant the variance. And what we're hearing right now is it seems, and you have to meet all 4 of those to grant the variance. And so the discussion seems like number 2, some members are inclined not to grant the variance based on number 2. But that's just what I'm hearing, so.
And a question, let's go back to the ordinance itself. For him to have, I guess you'd call it a copy edition or something added to it, he'd have to go before the council and request that, is that right?
I think the only alternative to a variance is a change to the ordinance.
A text amendment.
That's what I'm saying, a
Right,
text
and
amendment,
that would be something that would be required
He'd have to appear before the board.
from the town council.
Okay.
And I think that that's something that the planning board would want to look at and make a recommendation to the town council. And I think,
It could be a little more specific, like on new properties, because if you already got a property and you meet the house the tree limit. It's kind of ridiculous to add an addition, say, no, you can't do that, we're planting more trees. What is gained there?
And
Nothing.
I'm hopeful and confident that the town council and members of the planning board will look at this particular variance request and see what the effects of the ordinances written are, and possibly make adjustments that would make it easier in the future for people to comply with an ordinance.
I think the town council will be advised of this. I notice our town manager is taking a keen interest in this conundrum. All right, do I need to read
Let's go on to
The
at
other
least
ones?
consider the other two variance standards.
yes, okay.
Oh, can we,
Number 3, the hardship did not result from actions taken by the applicant or the property owner. The act of purchasing property with knowledge that circumstances exist that may justify the granting of a variance shall not be regarded as a self-created hardship.
I would have to say that it's clear to me, and I think to all the members of the board, that this hardship was not created by the actions of the applicant. It is something that existed and was, in fact, created by the imposition of a new ordinance after the property was.
Yeah, okay. Are we unanimous on that? The applicant didn't create this? Okay. Last one, the requested variance is consistent with the spirit, purpose, and intent of the ordinance such that public safety is secured and substantial justice is achieved.
I would have a hard time finding that this variance is consistent with the spirit, purpose, and intent of the regulation, where the spirit, purpose, and intent of the regulation is to require more trees, to be planted. I mean, it's clear that.
I think we're in agreement with that, and that brings us to the end of my script. We going to make a decision, possible continuance, or what are we gonna do next?
I will make a motion that based on the findings that variance standards 2 and 4 are not met, that this variance request be denied.
But the 1 and 3 would be met.
1 and 3 would be met, but, 1 and 3 would be met, but 2 and 4 are not, and therefore the variance must be denied.
Yeah, we are required to do.
Let me ask this question.
Wait, I think before discussion, we need to see if there's a second.
Yeah, if we give a continuance with the understanding that he'd appealed to the board of, let's just say the town board before a decision is made on the variance, how would that work?
Well,
Not well. Go ahead.
yeah, any appeal of this decision is
I'm not saying
to,
an appeal, a continuance.
a continuance.
I mean, we get to do this all over again?
Well, and I don't think we would, but I'm just trying to look out for the property owner. Give him the chance to go before.
That chance exists whether,
It's ominous, I know.
We would have to deny it
Deny it.
first.
I mean, there's 3 routes. He could withdraw his permit, and he could, even at this late time, I think, Brady, he could withdraw everything and just withdraw his permit, withdraw his request for a variance. Number 2, you could make a decision, and then, once the order is signed by the chair, he has a certain amount of time, he could appeal to Superior Court, right? Or he could do that and also talk to the council and see if the council could do some kind of a text amendment, in which case it wouldn't necessarily be retroactive, but maybe somewhere down the road he could do it.
Let me
I'm not sure if I'm
If we
thinking through.
deny it,
Pardon me?
if we deny his request, we deny the variance, and he goes before the board and it's changed, he can come back and apply for a permit again? He'll have to go through the process that way? If he still wants to put his deck in?
Did you say if you deny?
If we deny,
Deck's already started.
If you deny, then he'll make the decision as to whether he wants to move forward with all the trees or some of the trees and pay the 30%, pay the amount to knock it down, or he'll decide whether he wants to withdraw his permit deal with the text amendment and then wait.
Does the applicant understand all the options he has as outlined by our town attorney?
He can't speak.
What does it
anymore.
mean withdraw the permit? What permit? Permit to build,
Application.
Permit's under construction now.
Well, so much for that.
Okay,
it's almost complete.
we have, okay, thank you. I just felt it proper to interject there. Sorry about
Okay.
that. But let's, we have a motion to deny. Do we have a second?
I'll second it.
We have a
You can,
second.
either one.
All in favor, say aye, raise your hand. It is unanimous. We need to get that decision into the record.
Yeah, so what happens now to our applicant and to board members is that we will have an order prepared by Brady, and he'll get that to our chair at some point, and our chair will sign that. Once you receive that, then you have a certain number of days that you could appeal.
How many days is that, Mr. Golden?
I believe it's 30.
Yeah, and that's to Superior Court.
Correct.
Okay, very good.
Which is also stated on the official order, all the
Okay, yeah.
process.
Let me make one comment to the property owner. I faced a similar situation years ago when I was enclosing my downstairs. I live on West Beach. And the contractor said that we didn't need a permit, we just enclosed it. Well, that was not the case. When I was already 3/4 of the way through, so I had a cease and desist put up. So I appeared before the town council and explained the benefits of increasing the size downstairs, et cetera. And we also found out that the 200 or 400 square feet situation, it didn't matter that it could be expanded, because to change everything, everybody east of Highway 17 would have to have hurricane hangers on their roof, on their underside. So I requested a text amendment, and they granted it, and I was able to complete and close it downstairs. I'm just saying, if you go before the town council with a viable reason for your request, I think they might be open to giving you what you want. That's just my comment from my experience.
So what's happening now? Are we stopping construction? What are we doing here?
Brady?
I don't think I understand what's happening.
So as it was the decision of the board, the variance has been denied. So in order to continue with your project, upon completion and having final approvals, you have to have the requirement of DBH as, you know, as shown in the ordinance. So the 36 DBH?
Yes, that's per your sketch on the sheet.
Right, so the tree and vegetation plan that was submitted with the application and approved has to be met. And any modifications to that have to go under additional review and still have to meet the requirements, whether you're proposing to have the full DBH requirement per the size of your lot or the 30% reduction pay down. But those are really your two options now moving forward with your building permit.
Thank you, Mr. Golden. Lydia, is there any more housekeeping the board needs to do on this denied permit?
No.
No, we're good, okay. Chairman's comments is we still have an alternate position open. Please, your friends and neighbors, encourage them to apply. Some training does get made available periodically, and anyone watching this can see this is a very interesting board position. Staff member reports, anything? Motion to adjourn?
So move.
Second.
Done. Thanks. Good job, folks.
I think my tenure is up next March, something like that, I believe.
Well, they make exceptions in certain cases. You don't want any more? Okay. Very good.
I'll get you an official document that order, which basically just sums up this proceeding and the decision that was made, and then the information about the process for appeal will be in those
The
documents.
script that Lydia has done has been revised a little here and there. The only thing I need to add on it is to stop it, so you don't have to cue me to do something that doesn't appear. We're really operating at a whole new level now.
Yeah,